Touchstone conducted a payday payroll symposium on the 14th of November 2023. Among the speakers was Advocate Benjamin Magogo. He spoke about employment termination under the new Labour Amendment Act number 11 of 2023.
This amendment addresses a lot of critical issues. Some of them we can call them groundbreaking. Some of them we will have to agree very astounding to say, why are we here? But that's where we are.
He spoke of termination for operational reasons, termination on notice, and termination for misconduct.
Termination for operational reasons or retrenchment. Now, I think the starting point here should be that when the Labour Act was amended in 2015, the manner in which it was amended was that they had to delete the whole Section 12C that governed retrenchment and introduce a new one. So one of the biggest changes that you have now is that the provision of the Labour Act itself, Section 12C, defines 3 packages. It has 3 packages in there. Now you've got a minimum package, correct? So the minimum package is something that the statute should tell you. Then the second package is an agreed package. This is a package, as its name suggests, which comes from as a product of mutual discussion between an employer and an employee, and then parties can agree. And then the last one is what is referred to as an enhanced retrenchment package. Now this one is one where perhaps an agreement has failed between the parties and an employer has defaulted to the payment of a minimum package. But either the employees consider that the employer has capacity to pay, or the employer has gone to the ministry, to the retrenchment board, saying, I do not have capacity to pay. And because of the intervention of the retrenchment board, or adjudication, if you want to put it that way, the retrenchment board stipulates a package that has to be paid. That package is what is referred to as an enhanced package.
He also talked about a new addition in the Act in the form of giving notice that you have retrenched someone to the retrenchment board.
Then the second thing that is there, I think this was there before, you still have to give notice of the retrenchment to the Works Council, where there is a Works Council. In the absence of a Works Council, you give it to the National Employment Council. But in both scenarios, whether you give to the Works Council, whether you give to the National Employment Council, you need to serve or to notify the retrenchment board. Now, I will emphasize this point because as a result of this amendment, there is actually a crime that has been created for simply failing to notify the retrenchment board of a retrenchment. So you should know that this is not something, some of you will think that because there is an NEC, we've notified the NEC, therefore we've complied. The law requires you, having notified either the Works Council or the NEC, to also notify the retrenchment board. Another issue again that arises from the amendment is that negotiations can be held for a better package even after the notice has been issued. And when that notification certificate has been issued to you, the law also requires that it be pasted physically or virtually on a notice board for 7 consecutive days. And this is the retrenchment board office notice board or the an NEC notice board.
He also mentioned that failure to notify the retrenchment board can attract different repercussions. Some of them include civil or criminal sanctions.
The first one is that you actually can invite civil. The second one, you can invite criminal sanctions. Okay, now this one says, if that happens, the package that you have agreed with the employees to pay within a year becomes due within 21 days. So that is another effect of failing to notify the retrenchment board. If it is found that there is no basis upon which the employer has not paid, they are issued with what is called a non-compliance certificate. That's the second certificate. So the first one is a notification certificate. The second one is a non-compliance certificate, which is a certificate certifying to the whole world that this person does not comply with the law.
He also highlighted that failure to pay will also attract a different kind of certificate.
Okay, then what about employees? Can they also challenge the decision to pay the minimum package? So you don't want to agree with them a package which is better, or you have tried to negotiate with them just to show them that I can't pay anything more, but they still want something more. You default to the minimum package. The employees themselves are given the power by the law to approach the retrenchment board to say, this employer has capacity to pay. Now, in resisting that application, the first statutory requirement is for you to attach audited financial statements. So if you don't have them, you know you're in trouble already.
He alluded that if you try to liquidate your assets so that you avoid paying your employees, the law has provisions to assist employees.
If it is shown that you are where you are financially because of fraud, because of recklessness, or because of negligence in the way you've been running the company in the period leading up to the retrenchment, and if the employees manage to raise that and sustain that argument before the board, then you may also find yourself in much, much bigger trouble.
According to Advocate Magogo, it's easy for your organization if you consult your employees about your financial situation before retrenchment.
I read this this amendment on Section 12C as obliging an employer to consult employees before even thinking of retrenching. Consult them, make them understand your financial situation so that you dissuade any of this thinking that I have to go to the retrenchment board after I've been retrenched. If you don't do that, then you are guaranteed that if you don't have the discussion in the comfort or discomfort of your office, you are going to have it at the retrenchment board.
He also mentioned that once an employer has handed in his or her resignation letter, then that's the end of the story.
When a person says I've resigned, they've given you a letter of resignation and you've received it, that's the end of it. But however, on the flip side, if this person who has decided to go has communicated that I'm going, it is no longer unilateral if they have changed their mind. They now need your consent as the employer.
According to Advocate Magogo, the Act does not stipulate the retirement age.
So the Labour Act, as you know, does not define retirement age. Okay, so usually the age for retirement should be found in an agreement. It could be a contract, it could be a policy, it could be a collective bargaining agreement in respect of employees covered by the NEC, which has to stipulate the retirement age.
He also mentioned that if you need to terminate a contract based on misconduct, you need to have a hearing and the employee has the right to legal representation.
Termination by the employer for breach, which is following after an inquiry. This is Section 12.4a(b). An employer can terminate on notice for breach only after due inquiry. And by due inquiry, what is just meant is a hearing there. You must hear the other party, observe principles of natural justice, such as the audi alteram partem rule, among others, and ensure that the hearing is done properly.
In conclusion, Advocate Magogo mentioned that the employee has a right to mitigate.
Okay, because it's a statutory right. Give them the right to mitigate. So let them say what they want. I am the breadwinner. I am a war veteran. I fought for this country. Allow them to say that. So that when you then make your decision, you should say, I have looked at your mitigation and it is far outweighed by the seriousness or gravity of the offense that you have committed. If you decide, I don't want to hear your stories on mitigation, what do you want to mitigate? I quote you, we call it in flagrant delicto. I quote you on the act doing it. So why can you say you want to mitigation is a requirement. And if you do not mitigate, you find yourself having that penalty that you have passed.